Breaking news out of Washington, D.C. In case you have not heard, the Supreme Court has just agreed to take on a case examining the Second Amendment in the context of domestic violence. It's going to have major implications for gun owners across the country. We're breaking it all down now. Tune in and join the fight. Hey guys, Aaron Dorr here with a major update for gun owners. For decades now, the issue of domestic violence and the Second Amendment has been a very controversial space. In fact, for decades now, you couldn't even question the constitutionality or morality of these laws without being labeled a spousal abuser or some kind of a monster. This all began back in 1996 when the late U.S. Senator Frank Lautenberg added the Lautenberg Amendment to the United States Code. The Lautenberg language, as many of you already know, says that anybody who has a domestic violence conviction or a protective order incident to that situation may not possess firearms. It was the first time in America where non-felony conduct could get somebody disarmed for a lifetime. And the major news we're here to announce tonight is the Supreme Court has just agreed to consider a case involving the issue of domestic violence and someone being disarmed. And what they decide in this case is going to have major implications for gun owners across the country because this issue is still being litigated in state capitals across the country. So we're going to break the case down for you and how we got to where we are in this situation. And I want you to pay special attention to the arguments the government used in circuit court, which were thankfully rejected by the court, because it's going to show you just exactly how much tyranny flows through the veins of our current justice system. So here's the backstory. Everyone remembers last year's Bruen decision, and the Bruen decision said that any gun control laws needed to show how they survived or how they interacted with or flowed from the historical use of firearms in this country. In other words, if you want to pass a gun ban of some sort, you better find a way to point back to our nation's history where our founding fathers and the first, century of Americans adopted similar restrictions. That was the Bruen decision. It also did away with means end scrutiny. And what that means is prior to Bruen, the justices could decide they could weigh your gun rights against public safety. And they could say, well, yeah, you've got gun rights, but public safety outweighs that. And we lost that argument basically every single time. So in that context, a thug out of Texas named Zaki Rahimi, I want to be very clear. He's a complete thug. He's a gangster. He's shot up restaurants, shot up drug dealers, probably rivals. I'm not sure. The guy is a complete criminal. Make no mistake. But you don't have to be a criminal versus a good person for the court to consider whether or not the underlying law in effect is constitutional. So Mr. Rahimi shot up a bunch of restaurants and drug dealers in 2021. In 2020, though, the year before, he abused his domestic partner. Maybe it was a spouse, maybe it was a girlfriend. I'm not sure. We'll use that label. And so as part of that process, he was served a protective order, which, of course, barred him from possessing firearms. Fast forward a year, and when he was arrested for all these violent crimes, he had a handgun and a rifle on his person, and he was charged for that. After Bruen came out last year, Mr. Rahimi appealed his conviction in local court to the federal district court. He lost his appeal there. He then appealed to the Fifth Circuit Court of Appeals for them to consider his case. That is the background of how we got here. And recently, in the Fifth Circuit, which is very pro-gun, a 3-judge panel agreed with Mr. Rahimi that the domestic violence Lautenberg statute is not constitutional. The Justice Department, of course, has appealed that defeat, and the Supreme Court, in a major break of their own protocol, has agreed to consider this case when they come back from summer break. I say it's a break of protocol because ordinarily, after a major decision has been issued on any topic, but especially on the Second Amendment, the court knows there's going to be all kinds of challenges based on their new precedent. And they have always, as a matter of a habit or a matter of protocol, said, we're not going to answer all of your questions right away. We want lower courts, lower judges to percolate and to interact with what we have issued in this case. In this case, we're talking about the Bruen decision. And so the Supreme Court has decided that this case is seismic enough that they're going to weigh in and break that protocol. So that's the backdrop of where we are. Now, in the Fifth Circuit, where this case was argued, is where you're going to get a peek behind the curtain to see exactly how tyrannical, how monstrous our current Department of Justice under the control of Merrick Garland and, of course, Joe Biden actually is. You see, the justices were asking the DOJ, show us where and how the Lautenberg language comes from the historical application of the Second Amendment in this country. The first argument the DOJ used was kind of a macro argument. They said, well, actually, we don't have to do that. You see, the Second Amendment only applies to law-abiding citizens. Heller gave that delineation. Bruen upheld that definition. And so the DOJ said very simply, we don't have to do any of this because Mr. Rahimi is a criminal. Now, at first blush, there might be some element of common sense to that. We don't want to have violent criminals walking around with firearms. And so there's some element of that makes some sense. But it's a very dangerous precedent. Because if the government can simply say, oh, you're a criminal, you have no freedoms, you have no rights, that is a very dangerous road to go down. And the court blew the DOJ out of the water on that topic. They said, under the government's reading, Congress could remove unordinary or irresponsible or non-law-abiding people, however they want to define it, from the scope of the Second Amendment. Could speeders be stripped of their right to keep and bear arms? How about political nonconformists? What about people who do not recycle or, this is my favorite, drive an electric vehicle? Now, of course, the court was having some fun with the DOJ. Some of these questions were somewhat rhetorical, but you see their point. If the government can just deem somebody a criminal and then deny them their constitutional rights, we are not far off of being a dictatorship. And it's always been a concern, but it's much more of a concern these days with the Biden White House weaponizing the law enforcement systems and agencies against the American people. There are cases now where you could be labeled a criminal having never been charged with a crime in the case of a red flag gun seizure. And so what the court has said here is that there needs to be a deeper conversation because you can't simply declare somebody a criminal and then say they have no more Second Amendment freedoms. Thank God for this argument being shot down. The government's next argument, though, is truly heinous. It is truly tyrannical, and I hope you can absorb this and feel the rage that you should feel. The government said, oh, okay, you want precedent? We'll give you precedent. They cited the English Militia Act of 1662. Now, of course, America wasn't even a country until 1776. So you're going back about 115 years here, and they're citing the English Militia Act, which was an absolute tyrannical action by Charles II, and it was further added on to by James II, these two kings, to tyrannize the American colonies. It says, under the Militia Act of 1662, officers of the crown could seize all arms in the custody or possession of any person whom they judged to be dangerous to the peace of the kingdom. What does that sound like to you? What's a tyrant who says, anybody I don't like, I'm going to have my soldiers go to his home and grab his guns? Kind of similar to the tyrant we have in the White House today. And it was in response to tyranny like that that our founding fathers launched the Revolutionary War. And they said, you want to treat us like that? We will see you on the battlefield. And they gave us a country in reaction to tyranny like this. But the Biden DOJ will use examples of this kind of tyranny as justification for their current tyranny. It is insane. It is incredible to hear them use the tyranny of the British crown as justification to maintain tyranny on us going forward. Thankfully, thank God, the court struck this down hard. Here's a quote. It's kind of long, but just follow me here. After the Glorious Revolution, which enthroned Protestants William and Mary, the Declaration of Rights, codified in 1689 as the English Bill of Rights, modified the Militia Act by guaranteeing that subjects may have arms for their defense suitable to their conditions as allowed by law. This right, which restricted the Militia Act's reach in order to prevent the kind of politically motivated disarmaments pursued by Charles II and James II, has long been understood to be the predecessor to our Second Amendment. What does that mean in common speak? The courts are saying, are you people stupid? It was this kind of abuse that gave us our country. The reaction to this is what got us into a war. And it was once our country was free from that tyranny that the Second Amendment our founding fathers gave us guaranteed that no longer could American citizens have their guns taken simply because they were out of favor with the ruling class. Amazing just to comprehend the level that our DOJ will go in trying to justify gun control. The third argument the government used, again, they say, well, you want precedent? We'll give you precedent. The DOJ, with a straight face, I will tell you, went before the judges and said, we have a history of taking guns away from black people, from Indians, and from those who will not take an oath of allegiance to this country. And so that is grounds for supporting the constitutionality of Lautenberg. Think about that. They're literally using racism applied, used by the government in our nation's history as justification for gun control today. The court rejected this, and they said very clearly that this was an abuse of power back then. It was unconstitutional back then. It should have been illegal back then. And it damn sure is not precedential. It's damn sure not able to be used to undergird the Lautenberg language these days. And their argumentation was very accurate. They said these gun seizures were illegal because it was not based on behavior. It was not based on conduct. It was based on someone's skin color, for heaven's sakes. And so the court has rejected that argument as well. Finally, the government said that there were cases in Pennsylvania and Massachusetts at the time of America's founding where the respective states tried to limit the scope of the Second Amendment at the state level in their state constitutions and put codes of conduct on there. So you had to be a law-abiding citizen to be protected by the Second Amendment in Pennsylvania and Massachusetts. But I want to be clear, they tried to do this. It never actually happened. They tried to do it. It was never adopted in the respective states. And the court said that. The court said, well, this didn't pass. It didn't pass. And so it's not part of America's tradition when it comes to how we have interpreted and understood the Second Amendment. So I hope you can see, again, the tyranny and the desperation that our own government will use against the American people trying to take away our gun rights. It is absolutely breathtaking to comprehend. And so there's an awful lot at stake here for gun owners across the country. The code section, it's 18 USC 922 subsection G, subsection 8, has resulted in hundreds and hundreds and hundreds of thousands, maybe millions of Americans being disarmed who, in many cases, never committed a violent crime. See, in case you don't know this, you don't have to commit any act of violence to be convicted of domestic violence in a court of law. The normal situation that you hear about or that you imagine or see in a movie involves acts of violence. But in many cases, there is no contact whatsoever required for someone to be arrested for and convicted of domestic violence in a court of law. Now, the court may uphold the Lautenberg language, but we hope they don't, and we don't believe that they should, because America has always had a clear line as to, what separates people who can own firearms from those who cannot own firearms. And that line was violent felony convicted persons. If you had a violent felony, you could not own firearms. And of course, they should not own firearms. Everybody agrees with that. But what Lautenberg did was made it very normal for misdemeanors to be used as grounds to disarm people. And as we have experienced over the last couple of years, the left is trying to augment that, to add that to that list, other non-violent misdemeanor situations to result in someone being disarmed for a lifetime. It's Pandora's box. It's Pandora's box. And so when it was open in 96, the left has always been trying to bolster that. Now, of course, people might say, so what? You want convicted felons to walk around with firearms? Well, slow your roll on that. Violent felony convicted persons were not walking around in society until very recently. A couple generations ago, the American people in our justice system had a very swift reaction to somebody who was charged and convicted in a court of law for violent felony crimes. If you were a convicted murderer, a rapist, a kidnapper, an arsonist, a violent criminal, you were executed. You were shot. You were hung by the neck. You were executed. That is a biblical, lawful, constitutional solution to the problem of violent persons who are convicted in a court of law. That would deal with all of those people. But for non-violent felony convicted persons, we do not believe those people should be disarmed for a lifetime. We've done videos on this in the recent past. A single mom who steals food from Walmart one too many times and gets a felony conviction, well, she should make that right, and we're not excusing her behavior. She should not be disarmed for the rest of her life. The left has created the problem that we're seeing today. You see, they don't want to prosecute criminals. They give them all a pass. So what should happen, and the easy solution to the issue of domestic violence, is if a person committed felony level acts of violence, prosecute them for a felony. Stop screwing around. Don't give them plea deals. Don't give them pretrial diversion like Hunter Biden got. If somebody commits felony level violence against their domestic partner, prosecute them for a felony. And when they're convicted, they will lose their right to keep and bear arms as a violent felon. But again, the radical left prosecutors, Soros prosecutors, they are all of them soft on crime. They don't want to do the hard work of going after criminals, and they make these sweetheart deals. Their system has created the problem that we're in today. And so their solution, of course, is not to fix the problem they created. Their solution is to come after our gun rights, to come after our freedoms. It's always been that way over the course of human history. The government says, if you want protection, if you want security, sacrifice some of your freedom and we'll give it to you. Thankfully, here in America, our country was built on rebellion to this type of heavy hand, this type of tyranny. Our founding fathers wanted no part of this. And thankfully, the Fifth Circuit is rejecting these arguments from the DOJ. And so when that case was appealed by the DOJ, we now have this case headed to the Supreme Court for consideration. It's going to be a major case, guys, no matter what happens. It's going to take some time for it to be adjudicated. And in the meantime, leftists in your state capital will be trying to add more and more misdemeanors to the list of things that can be used to disarm you and disarm me for a lifetime. Help us fight back in the legislature as we work in court to hold the line for freedom. Hit the link below. Join the organization today, guys. We're fighting for you. We need your help. Also, subscribe to our YouTube channel for more content and share our video online. Stay free.